active in the war. Exactly. So, off the top of my head, there are many instances. Many instances. But I'm going to have you go back to the prosecution of war crimes. And the start. I remember that you said, explicitly that there was nothing known as international criminal law of some sort, and then you and some other people were like the pave makers and the groundbreakers in that regard. Now let's talk about the prosecution of war crimes. People are concerned because a lot of people very readily say the International Criminal Court always targets African leaders, as the case may be. Is that what is the real state of things, or does it just happen? Let me just leave it that way, so you answer.
Well, it is true that a sizable amount, in fact, if not all, the situations that have been referred to the ICC have emerged from Africa.
Okay.
What is not true, though, is that the court specifically targets African countries. I think that's inaccurate. I think the reality of the situation is that for those of us who practice before international courts of tribunals, you realize that every situation, with the exception of Sudan and Libya, have actually been referred to the ICC by the African states themselves.
Okay.
And the reason for that is that once you are a signatory to the Rome Statute of the ICC, which is the enabling instrument that created the ICC, you have certain obligations to that court. One of those obligations is that you are able to refer situations that occur in your country, or what we call jurisdiction, to the court. And in the case of Uganda, which was the first situation that was referred to the ICC, that situation with the Lord's Resistance Army, LRA, was actually referred by the government of Uganda. Congo-Brazzaville, Congo DRC was the second situation. The Ntaganda trial and the Katanga trials were actually referred by that country to the ICC. In the case of Ivory Coast with Laurent Gbagbo, even though Ivory Coast, Côte d'Ivoire, which is what the country is now known, was not a member of the ICC, but the country itself voluntarily referred the case of Laurent Gbagbo to the court. Now, the Kenyan situation was also referred by the government of Kenya to the court itself, and that's been the subject of a lot of speculation, whereby a sitting president was actually facing trial before the ICC, and which led to all the opposition of the African Union claiming that the court targeted African leaders. Now, the cases of Sudan, Darfur in Sudan, and Libya, the Gaddafi situations, were referred to the court by the Security Council of the United Nations. But the court has opened investigations into Nigeria, into the Palestine, Gaza, into Syria. But there have been no indictments drawn from those situations. So it may seem at face value that the court is targeting Africans, but that's not entirely correct.
Okay. I'm going to ask you at this point in time, what it entails to prosecute war crimes?
War crimes, or any international crimes, or war crimes is just, there are many crimes that make up a war crime. So there's murder, there's enslavement, there's sexual violence, there are myriad of crimes that constitute war crimes. But so let's talk in terms of international crimes. International crimes are extremely complex, both in terms of their investigation, but more importantly in terms of their prosecution. And the reasons for that are obvious. They're very large scale in terms of their occurrence. In other words, they occur simultaneously throughout the country. That is the subject matter of that situation. But more importantly, you are always called to investigate them after so many years or months of their occurrence. So, as international investigators, you are going into a jurisdiction that is unfamiliar to you, because the investigation team is made up of investigators drawn from all over the world under the auspices of the ICC or the United Nations. So you're often operating in territories that are completely unknown to you. The subject matter of the investigation is perhaps even unknown to you. In other words, you don't understand the background to the conflict, and you go in blind. So you ultimately have to rely on locals which we discourage because you don't know which side those locals are on. You don't know what side of the conflict they're on. So it's extremely.
So what do you then use as the witnesses? What are you left with if you're not sure as to the veracity of the stories that these people will give?
Well, what usually happens with international crime investigations is that the human rights organizations would have gone in before us anyway to conduct their reports, their investigations with a view to assessing what has occurred. Sometimes we rely on those investigations, the reports, human rights reports to an extent, and then use that as a platform or a template to then go into the jurisdiction. But what is most challenging about the investigations before we go to the prosecutions is that you have to determine a strategy upon which you are going to investigate crimes. If I give the example of Rwanda, as you pointed out to your audience, there were almost 1 million people killed in Rwanda.
Yes.
Now, I can assure you that there were almost 200,000 people involved in those killings. Now, you have to determine, because they are ad hoc tribunals in nature, what will be the template or the matrix of deciding who you should prosecute. You can't prosecute everybody. You don't have the time, you don't have the resources. So we decided in Rwanda, for example, to prosecute those who bore the greatest responsibility for the atrocities. In other words, the government echelons of government, military brass, and some religious leaders.
Okay.
As you know, or you don't know, there were many more Rwandans, Tutsis, killed in churches than anywhere else. That is the untold story of the genocide in Rwanda. There were many more people killed in churches than anywhere else. For obvious reasons, churches were preconceived locations of safe havens.
Yeah.
So people would gather in churches, and they knew that from previous conflicts. So to answer your question is to decide how you go about the investigation. Do you investigate sexual violence, which is very common in conflict situations? Women and rape is used as a tool of war often. Do you investigate low-ranking soldiers, which we call foot soldiers? Do you go for the leaders? And if you go for the leaders, do you go for the political leaders? Do you go for the government leaders? Do you go for the spiritual leaders? And then in terms of the prosecution, the prosecutors drive the investigation, which is something you don't see often in Nigeria. The investigations drive the prosecutor. But we forget that the prosecutor bears the burden of proof, and it is him that has to discharge that burden of proof before a court of law. So clearly he's the one that knows what he needs to be able to discharge that burden, and consequently he ought to drive the investigation. So what you find in an international situation is that the prosecutor's office carries the mandate of actually directing the investigations and collecting the evidence, and then deciding on a basis upon which the prosecution will take place. And that's just putting it in a very general sense. It's a little bit more complex than that.
I was going to ask about okay, let's not make it complex. You've touched on rape as a tool, very readily used, and I know that last week, when I heard you speak, you were talking about the Hutsis and the Tutsis, and the fact that you're descriptive, very descriptive, and yet very detailed background as to why it was so, the women and all that. Now, in cases where rape has been used incontrovertibly, what how does it then come to bear before the court? Do we then need to keep proving in that instance, when it's very clear to everybody that these people have perpetrated such heinous crimes against women and the children, female kids?
One of the important things that came out of the prosecution of international crimes before international courts was the extension of the definition of rape and what we as prosecutors needed to prove rape before a court of law. In common law jurisdictions, you need to be able to adduce evidence of lack of consent. So consent as a term is key. In other words, once a woman withdraws consent, then you can be guilty of rape, because the consensual nature of it is important. In the context of international crimes, the jurisprudence that emerged from the work that we did before the United Nations courts was to the effect that the nature of a war or conflict is so coercive in itself that you cannot then talk about a woman's ability to consent or not to her being raped. And I'll give you a practical example. Oftentimes, in the conflict situation, women seek protection from attackers. They seek protection for themselves, they seek protection for their children, and they're of course the most vulnerable members of our society. So if a woman comes to you and says, please protect me from attacks, and you as a man then turn around and say, well, in return for protecting you, I'm going to rape you every night. And she says, okay, that's really not consent, because she really didn't have a choice in the matter. The circumstances were so coercive that she was clearly unable to exercise any free choice. And that's one of the important things that came out of the jurisprudence of international criminal law, that you cannot talk about consent in the context of such coercive circumstances. And that's one of the important principles that came out of it.
Okay, his name is